Welcome to the Capital Stack Show, Real Estate Syndications and Funds.
Welcome back to the Capital Stack Show, Real Estate Syndications and Funds with Shams Merchant. Shams is a commercial real estate private equity attorney who represents syndicators, sponsors, and real estate funds nationwide, helping structure deals, raise capital, and stay compliant with securities laws. I'm Leanne Lyon, and today we are talking about whether you really need a PPM and when setting up a real estate syndication. Great to see you again, Shams. Let's go.
Yep, great to be back, Leanne. Thank you so much.
So, Shams, first of all, what is a PPM and why is it such an important part of a real estate syndication?
Sure, yeah. A PPM is essentially a private placement memorandum, and it is probably the most used acronym in in this uh, in this space, or not acronym, but shorthand, right? PPM. Um, it's used. That word is used so much in this industry because everyone thinks that it's this really, really important thing and it's the most biggest deal of doing a syndication or a fund or private equity, and everyone's talking about their PPM, and it's all just it's really at the end of the day, it's just a memorandum that this provides disclosures to investors about the project, the deal, or the investment that they're potentially going to be making. That's all it is.
So, what do sponsors often misunderstand about what a PPM is actually designed to do?
Yeah, sponsors think that a PPM is that document that's going to help them raise capital, which is so far from the truth. All the PPM is meant to do is just provide, like I said, disclosures. It is providing risk disclosures. It is providing information about the investment itself. It's not supposed to be this super comprehensive document that is going into the deep nuances of the actual project that's being done, right? That's not the goal of the PPM. The PPM is meant to cover the sponsor from a legal perspective. It's meant to cover the sponsor from a securities compliance perspective, and it's meant to give investors all the pertinent information that they need in order to help them make a judgment decision about the investment, right? And that's essentially what the goal of the document is. It's not supposed to be a marketing uh document that's out there that's going to help you actually raise capital, because there's 50 pages of just information in there usually that is just providing very standard disclosures, right? And so it's not a marketing document. In fact, it's probably the opposite of a marketing document, because it has things in there oftentimes that say, you understand that you have the risk of losing all of your money if you invest in this offering. That is true. Investors can lose all their money when they're making an investment. It's like investing in anything, and it's an investment. There's no guarantees, right? And so it's just making all of those things clear before someone gives you money to invest, for you to invest in something. Um, Look, I think that the PPM, if it's structured the right way and designed the right way, it can amplify your success from a marketing standpoint, because it can show that you've done the legwork and that you've provided all the necessary information to the investor, and it's structured fully compliant and in accordance with the law, and contained all the necessary information and disclosures that they need. So it can help show that, but it's not supposed to be your marketing document. That's what a pitch deck is for, right? That's what a marketing pitch deck is for. It is not what the PPM is used for. However, a bad PPM, or a PPM that is inconsistent with your marketing materials and your pitch deck, that can cause you problems, right? That can cause you legal issues. That can even cause investors to not invest in your deal, because they'll look at it and say, you haven't structured this correctly. There's missing information. There's information that's not relevant to the deal. Um, all of those things, right? And so again, PPM is not a marketing document, but can affect your marketing if it's not structured the right way.
Yeah, my big takeaway right there. It's not a pitch deck. It's not standing on the side of the road hailing down investors, and it's not supposed to be. So in that case, is it legally required every time somebody puts together a real estate syndication, or are there situations where people think they can just skip it?
Yeah, the answer to that question is no, you can't skip it when you're doing an offering. It is still a required document that you should be providing to investors because it is that one document that is going to, again, provide all the disclosures about the project, the deal, the investment, and whatever it is that you plan on doing with someone's money, right? Because and let me again clear that up again. It's a disclosure document. People think that the PPM is something that's signed. PPMs don't get signed. They are providing disclosures, right? What gets signed is the actual operating agreement or the partnership agreement if you're a limited partnership, or an operating or company agreement if you're an LLC, depending on the situation and how that investment is structured. Right? Typically, the two most common used investment entity vehicles, right? Um, that's what gets actually signed, right? The PPM is just a disclosure document. Again, it's not some scary thing, but yes, without it, you are going to be missing a whole bunch of disclosures that if something goes wrong and you get sued or the SEC gets involved, you're gonna have problems. That's what it's there for. It's not like the law itself says, "Oh, you have to send investors a PPM every single time you raise capital." There's no such thing in the regulatory code that says you have to send a private placement memorandum. It's a requirement of doing an offering. That's not what the SEC says. It's the standard way to create an offering and to provide the disclosures which the SEC says that you have to make. The SEC tells you the disclosures you have to make. It doesn't tell you how to make them. The PPM is the vehicle that has been created over time. It's the document that is accepted in the industry and by the market as the way to provide those disclosures to your investors.
Okay, so getting this straight, the PPM is not technically required as a PPM, but the disclosures are required. The PPM is an excellent vehicle for getting those disclosures to the investors, even though it's not a signed document.
Right. It's the medium through which you comply with the law. It is not the actual it's not something that actually is written in the law as being the medium that you have to use. But really, if you're not sending one and you're using something else, I don't know what that would be. Um, you're probably not, you know, you're probably missing a bunch of things, right? So it's just over time, over I don't know, 100 years of investment offerings being made and the securities laws being established the way they are in this country, that has became the standard of how to and what the SEC, and because it's become the standard, it's also what the SEC is going to be the most um, accepting towards because it is what everyone's using, right? You can also use what's called an investment circular, right? Which is also something that has been created that is similar to a PPM. Again, it's the medium, right? But what investors look for, what the SEC looks for, what the market looks for is a PPM. So again, not something that's written inside of the legal code um, of the statute of the United States of the securities code, right? It's not some it doesn't say the words private placement memorandum has to be, sent to every investor. That's not how it works. It is just what the industry has accepted as the way to do it. So if you go outside of what's accepted, you're probably not gonna you're playing with fire is what it is.
So, what kinds of risks are sponsors exposing themselves to when they decide not to use a PPM?
Yeah, they're exposing themselves to rescission rights that the SEC could potentially penalize them with. They're they're opening themselves up to breach of contract lawsuits, breaches of Securities Act and of securities regulations. Right? They're exposing themselves to significant potential criminal liability. Right? Because they fail to disclose something to the investors. Right? So if you're asking like what the specific risks are, well, they're dependent on the deal, right? Um, each deal has its own specific risk disclosures. Each deal also has its general risk disclosures about investing in a real estate deal. What are the risks of investing in any real estate deal? That should be in the PPM. But what are the specific risks of investing in this real estate deal? That should also be in the PPM. What are the risks of investing in multifamily properties located in New Jersey? That should be in the PPM because those risks are different than investing in a multifamily property located in Miami. You don't really get hurricanes that much in New Jersey. You get a lot of hurricanes in Miami. So maybe it's a good idea in your risk disclosures to say, hey, one of the risks is Mother Nature out here in Miami, right? We get hurricanes. Here's what could happen if a hurricane decided to roll in, and what could that do to this deal? What could that do to this project? How could that affect your money, right, and your investment, right? And that's just a very basic like example, right? There's a whole host of other things in there. Um, so those are, but that's a good example of like at least at a very basic sense what should be in there.
Well, you said it's, very basic, but it's also very specific, which brings me to my next question. On a scale from 1 to 100, how detailed should a PPM be when it comes to risks, fees, deal structure, and investor expectations?
What a great question. That is a bit of an art and a bit of a science. um, because look, you don't again want to be, I wouldn't say the number is 100% by any means, because you're going way too in the nuances at that point. That's way too detailed. You don't need to provide details of that magnitude either, right? Because some things you actually can't provide and predict because it's an investment and you don't know what's going to happen. So like you can't really go that detailed. You also can't be all the way on the other side of the spectrum and not provide any information because that's not doing you any good either. There's a good balance. It depends on the deal and the project, and it depends on the asset class, and it depends on type of offering it is, on what that balance, like what that perfect balance looks like. And I think it's different for each offering that we do. So those are some of the judgment calls that we make, and look, and that's why people engage lawyers to do this, right? Because we are making those judgment calls for them, right? Like, do we need to include the disclosure here, or is this not really a pertinent disclosure? Do we need to, provide context around this project plan in some certainty, or is the context here plenty? Because you also don't want to put too much in there, because if you overdo it, it could also be just burdensome for an investor to review and look at. And again, this goes back to my point of marketing. Pitch deck is not meant to be a marketing tool, but it can definitely derail your marketing efforts if you're putting so much in there that's just that's not even necessary to put in, and investors are reading it and getting just freaked out by all the things that could go wrong, right? Like, you know, it it, you don't also want to do that either. So you want to strike a good balance. You want to have all the legal items properly structured, and then you want to make some judgment calls along with your counsel about what the disclosures actually look like. Um, and so that's what's important.
That is all really great information. So, can you share an example of a situation where having a well-drafted PPM helped prevent a much bigger issue later on?
Yes, it's happened more times than I could probably count, because even with great sponsors and great deals, things go wrong. That's the nature of investments. That's the nature of real estate investments in particular, but anything in private equity, there's again, risks involved. And so, yes, there have been times where deals have gone south, and you know, the sponsor has been threatened with lawsuits and things like that. And each time we were able to point to the offering package, right? The PPM, along with the operating agreement or partnership agreement. And remember, everything goes hand in hand. It's not just a PPM, it's having everything structured properly, and making sure the whole set suite of documents is protecting you. Um, and we were able to point to various disclosures in there about the deal that made it very clear that, look, this is an investment contract. Um, you knew the risks of investing in this project. The sponsor, you know, didn't do anything wrong. They didn't commit fraud. They did the project the best they could, but they lost money. It happens. This is why you spend money to structure these things up front. This is why my job is, which is why I have a job, because this is when you, you know, y- this is when that investment that you made in doing it the right way protects you from millions of dollars of lawsuits and liability. So we were able to essentially push those, potential threats back, and make it clear that nothing wrong was done here, but also that the proper disclosures were made as far as the risks of that investment, and we were successful in doing that. So that's what these documents are for. That's what these disclosures are made to do.
Perfect. And again, why we rely on professionals, which leads me to my final question for tonight. What mistakes do you see people make when they rely on a template or try to piece together a PPM on their own?
I've seen the craziest things people send me, especially with AI now. Um, I yeah, I mean, I don't know where to start. I see a bunch of mistakes. I see disclosures in there that shouldn't be in there. I see disclosures that should be in there aren't in there. Um, I see terms that are just crazy, like, you know, uh, words like guarantees or um, uh, preferred returns not structured properly, waterfalls all over the place and inconsistent with the actual deal itself, or the operating agreement or the partnership agreement. I've seen just plain old just uh, AI hallucination, paragraphs of, of 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 things of law that are just not even real, or don't even apply to the exemption being used for that particular offering. I've seen um, uh, I've seen docs that are structured for a pure private equity deal using a completely different exemption than a real estate deal that doesn't even mesh. I mean, it would completely not be. I don't even know what would someone make out of that. It would not work. So it's just very dangerous, I think, to again do a DIY. Plus, the biggest thing of that is the first question someone's going to ask you. Let's say you do it the right way, or you somehow figure it out, right? Which is great. I'm not here to sell documents to people. That's not what I sell, right? I sell one, doing successful raises, and sell protection, right? I'm an insurance policy at the end of the day, right? The first question someone's going to ask you when something goes wrong is, who was your attorney? And, um, you know, uh, how did they draft these documents and all of that, right? And if your answer to those questions, I drafted them myself, you've lost at that point. You've already lost the battle, right? Because you have nothing to fall back on. You don't have, like, you can't, like, you can't rely on counsel at that point because you didn't use counsel, right? And so that's the biggest thing that I'm providing. It's documents are just a part of that. I think it's the being able to rely on our professional services, and designation, and um, credentials, to be able to, when things go wrong, to be able to have a backstop to your liability.
AI hallucination is completely real. It really happens. I asked a DSCR question and it totally gave me a residential DSCR answer, and I was in a commercial DSCR questions.
I think AI is great. I use AI every day to draft documents. I wouldn't imagine drafting documents without AI anymore, because it's helps me draft documents way faster for clients, get work out quicker, um, and expedite things for clients, especially document delivery. Again, we're not selling documents though, so
And you know what to look for. You know when it's hallucinating. The average person will not.
right, it's a discretion that's what you're paying for, and it's the knowledge of gained after doing hundreds and hundreds of deals, right? That is what you're paying for, not documents. Within 2 years, I think I can press a button probably, and AI can probably draft me every single document within, like, a minute. I 100% believe that's going to happen. But so what? You know? Like, I could, like, that doesn't change the service that I'm providing, because it was never about delivering documents in the first place.
Well, this is, as always, very fun. Thank you. And that is it for today's episode of the Capital Stack Show. real estate syndications, and funds. For more information or to connect with Shams, visit www.cre.law. Thank you for listening, and remember to like, subscribe, and share this episode with someone building or structuring their next real estate deal. Great to see you, Shams. Thank you.
Thanks, Leanne.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.